In LA County, when I would see pro se, people without attorneys do the case on their own, it was like there were 10% that knew what they're doing, followed the rules, followed the paperwork, did a good job. Usually they're like engineers or accountants or maybe an attorney who practiced somewhere else. But 90% of the time, it was like stuck in the mud. They didn't know what the process was. And I think it's not even just that they don't know what they're doing, but they also hold up their own process, which gives other heirs, other family members time to get upset and object. Is that what you see in San Diego as well?
Yeah, time to object or creditor claims have additional time to make a creditor's claim against the estate. The biggest issue I run into often in that situation is I get retained later on in the case because they can't figure out, the pro per can't figure out how to do it. And by the time they finally contact an attorney, house is in foreclosure.
Right.
Because it took them so long to get to the attorney stage or clear their defects before the judge can give them any ruling. Properties in foreclosure, and we're in a rush, and if we can fix it, we can. But more often than not, we're looking at a foreclosure, and not a whole lot we can do about it at times.
Big difference from LA to Orange County is in LA, in my experience, if there's equity, almost all the judges will do ex partes and hold a foreclosure to support the estate. In Orange County, in my experience, most of the time, the judges will say, hey, you had your notice, you had your period of time, these are the laws, good luck, you're on your own. What's it like in San Diego? We have three judges, they all different, or is there a similar pattern?
Well, we have three judges now. Judge Bostwick just announced his retirement, so we'll have a new judge stepping into the bench in October. I don't know what Judge Belsky will do once he takes the bench. But I do know Judge Sherling and Judge Kennedy will grant ex parte if necessary. I've gone into both of them in emergency hearings to save the property, get limited authority. You have to get a little creative. You might not get your general petition appointed. You might need to go in special administration with limited authority to save the property and negotiate with the lender or get it listed in essentially a fire sale if needed. So the San Diego County will grant ex partes if you tee it up properly. I think that leniency we talked about earlier, if I come in and they know it's me, it's a good chance I'll get it granted versus somebody else because I've done it before and they see how it works. I know Orange County, a lot of times you're going to be dealing with a magistrate versus a city trial judge. So they are more hesitant to make aggressive rulings versus a judge that knows they have cover to
Right.
make.
So just to break down a little bit what you just said for those who are newer on the call. So what he's saying is they come in the 11th hour, they tried on their own, they were stuck in the mud, their foreclosure's 3 days away, they walk into Zach's office on their knees crying, help! And so basically what you can do is file, the term he used was special administrator, meaning you're not really approving the estate to act on behalf of you're not approving the petitioner on behalf of the state, but for special circumstances, i.e. to get the property sold, give us the power, and we'll make sure all the money is kept under the control of the court by requiring court confirmation and other procedures. So there's a procedure to do that. And when he comes in and suggests that whole package, and the judge sees him, and he's a good-looking guy, he's dressed nice, but more importantly, he has a track record. They go, yeah, okay, we'll give you that shot. And you'll see petitioners, on their own, or even attorneys that don't know what they're doing, not teed up properly. And the judge will say, nah, it's not going to work. Because they know if you don't know to use a special administrator, they're not going to give you authority. They don't want you to sell the house and run off with the money or whatever is going to happen.
The judges don't want to always tell you the answer. They don't want to come up with the idea of their own. They want you to come up with the idea. And if you come up with a clever idea, they're willing to entertain it. If there's enough legal precedent and foundation for them to make the ruling, they certainly will. I had one just recently that I kind of puzzled Judge Kennedy, and she said I had to go talk to the examiners and see if this is something we could even do. And turned out they could. I kind of just threw a bunch of theories against the wall, and one of them stuck, and it worked. We saved the property from foreclosure and got it sold. So you got to get creative with it. But if you come with enough logic and reasoning and law, the judge will typically grant it.